Welcome to Notable Approvals. I am attorney Amanda Shaffer. Before we get to our case today, quick reminder, don't forget to like us, follow us, Facebook, YouTube, Instagram, wherever you're watching. If you are watching on Facebook or YouTube, our contact information scrolling across the bottom of your screen, or maybe it's that way. On Instagram, you can go to our bio page and find our contact information there. So let's get to the case. This is going to be a relatively quick one today. Relatively quick for me, that is. So, client who resides in New York County with his spouse, he had his green card approved based on his marriage to his U.S. citizen wife. He is a native of Taiwan and a citizen of Taiwan and New Zealand. He last entered the country on January 7th, 2023 on an H-1B visa. He is a senior UX designer. I believe, I'm not sure the difference between UI and UX. One is what you see on the website, and one is behind the scenes, I believe. I think he does one or the other. Smart guy. He married, so he met his U.S. citizen spouse, I believe, when he was here previously. And I forgot if he was here as a student or if it was previously on the H-1B. And they started dating, and they continued to date even when he had to go back to New Zealand to get his H-1B. And even when there was a presidential proclamation that prohibited him from returning on the H-1B. And a lot of people who are watching right now may know what I'm talking about, may have encountered a similar situation. This was during COVID when, at the time, President Trump issued a presidential proclamation where basically no one could come into the country on a visitor work visa. So they ended up being apart a lot longer than they planned on being apart. But he finally did come back to the US to work on his H-1B, and they got married in August of 2022. Now, I remember when they came to me, they were like, we're planning on going back to New Zealand so she can meet his family and everything by the end of the year. Should we wait to file until we get back? And normally the answer is yes, because in the majority of the cases we see is someone's in the U.S. On a visitor visa, overstayed even if they haven't. If you leave the U.S., you're abandoning your application. In his situation, well, I guess it was similar that we didn't want to abandon the application, but he was on a dual intent visa on the H-1B, and it was still valid. He was still working for the company, so he was able to come back without a problem. We did file right after they came back. I probably just confused you if you're listening, but the important thing to note is that you have to be careful before you leave the country, especially if you apply for adjustment of status. You want to make sure that even if you have a travel document, you want to make sure that you're not abandoning anything. So we could have filed the I-130 when they came back, filed the adjustment, because he actually got his travel document and work permit approved the same day as his green card, which means he doesn't need the work permit or travel document. Not sure why they even bothered. So anyways, so we filed for them early January 2023. And I'm sorry. We filed in March of 2023, 6 months. Yes, I can do math a little bit. I can do. And they just found out that they got approved. No interview. I remember even there was a delay because we hadn't submitted the medical exam, and the client took a little. He didn't get it. He couldn't get it right away. He had to wait a little bit. So it probably would have gotten approved even quicker. So you can submit the medical exam with your initial paperwork. We have a habit of not doing that because up until very recently, these cases were taking like 2 years, and the medical exam would expire and they'd have to go do it again. But we should probably rethink that because they are starting to come in quicker. Although I will say for New York, this might be a record for us. May have had one just under 6 months. I know in Boston we'd had one in 3 months, but New York City at least has sped up that part of the process. So, how did we manage to do it so fast without an interview? Well, it all comes down to the evidence. We had a lot of good bona fide marriage evidence, a lot of joint finances, including joint lease and a renewal lease. We had a joint checking and savings account. We had about 2 years of statements and put in every few months. Joint Con Edison bill, a joint Verizon plan. I'm going to skip these two. I usually talk about these in the order of somewhat in the order of importance. So I'm going to skip around a little because I got two interesting ones at the end. Evidence of the vacations that they've taken together. So in the last 2 years, they've gone on about 9 trips, which is pretty sweet. Mostly, we just showed photos of them in different locations, but we did have some flight confirmations as well. We had a wedding thank you card to the couple from the U.S. citizens petitioner's parents. We had photos of their engagement and their wedding. And then we had, of course, additional photos. And then we did include the beneficiary's visa denial letter due to the presidential proclamation to show that this is why the parties were living apart for so long. They were meant to be together sooner, but unfortunately had to wait. So the last two things I wanted to save until the end because they are unique in that they were the first time I've used this type of, actually one of these I've used before only once. First time I've used this type of evidence in a marriage case. So one is from Splitwise, a Splitwise transaction for 2 years. If you don't know what Splitwise is, it is a way, it's like an app on your phone that if you, let's say you go to dinner with a bunch of friends and you need to split the bill, one person pays for it and then everyone gets charged. And it's actually really cool because if you, like I've gone on trips with a group and it somehow balances it all out. So if different people pay, they get the right reimbursements. You can also send and receive money on the app. So we showed all their transactions together, showing that, they were sending money back and forth and buying things jointly and whatnot. And that was in addition to the bank account, but because he wasn't in the US the whole time, they weren't using the joint bank account as much, if I recall. But regardless, it's just extra evidence that's great to show. And then this one I really liked, just because I'm a nerd for good faith marriage evidence. So they had the U.S. citizen petitioners partnership-based temporary visa application for New Zealand with evidence that they had a genuine and stable relationship and the approval notice. So what does that mean? So we don't have a similar type of visa here in the US, unfortunately. But basically, they have this type of visa where you don't have to be married in order to come temporarily to New Zealand to be with your partner. You just have to show what they call a genuine and stable relationship. I'm not obviously an attorney in New Zealand, so I'm not exactly sure, how different it is from a good faith marriage that we have here in the US. I did see all the evidence they submitted, and it was pretty on par with what that list I just ran through. I think they also sent their communications as well to show that they were communicating despite being on other sides of the world, literally. But that's an interesting piece of evidence because people don't always think of that. It is rare. We don't have it in that many circumstances where one partner, where their parties are separated, one goes and sees the other and then returns, and then we file for the person coming to the US. So that was just a cool one to see that I wanted to mention. But yeah, that was it. I mean, not it. That was a lot of joint evidence, a lot of good joint evidence. And we didn't, again, it's not like we put in 1 month of a bank statement. We put in multiple months. So because of that, our client, he is receiving his 2-year green card, which means in 1 year and 9 months, in that 3-year period before the 2-year green card expires, he will need to file his I-751 petition to get his 10-year green card and remove the conditions on his residency. And if the couple is still married and living together in 3 years, he will be eligible to file for citizenship. And that's all for today. Thank you for watching. Don't forget to follow us on Facebook, YouTube, Instagram, wherever you are watching. And if you find this video to be helpful or know someone who may, please go ahead and hit that share button or that save button so that we can get this helpful information out to others. And again, we're here for you. Contact information. Go to our bio page on Instagram, YouTube, Facebook. Check out your screen. Bio page as well works too. Thanks for watching and have a great day.